What if one director could secretly use two identities, two DIN numbers, two corporate records, and two separate faces in company filings? Sounds dangerous for corporate governance, right? That is exactly what Section 155 of the Companies Act 2013 prevents. Because under company law, one person can have only one DIN. Introduction to Section 155. Section 155 deals with prohibition on multiple director identification numbers, also known as DIN. The section creates strict rule that every individual can hold only one DIN for lifetime. No duplication is permitted under law or legal provision. If a person has already been allotted DIN under Section 154, the person cannot apply for another DIN, cannot obtain another DIN, and cannot even possess more than one DIN. This prohibition is absolute under company law. One person, one DIN principle. The most important principle under Section 155 is simple. One person equals one DIN, and that one DIN remains valid for lifetime. The law does not allow multiple corporate identities for same individual. Why DIN exists? DIN acts as permanent identity number for directors. It helps regulators track appointments, resignations, and directorships across companies. DIN creates transparency and accountability in corporate governance. Why multiple DINs are dangerous? Suppose one individual holds multiple DIN numbers. The person may hide involvement in companies, manipulate records, avoid detection in fraud investigations, or misuse corporate structures secretly. This can destroy governance transparency. Objective of Section 155. Section 155 exists to ensure unique identification of directors. The law wants every director to remain traceable across all companies and filings. Transparency becomes impossible if one person uses multiple identities. Lifetime validity of DIN. DIN once allotted remains valid for lifetime. There is no requirement to apply repeatedly. Even if director joins multiple companies, the same DIN must continue everywhere. This is one of the most important exam concepts. No need for reapplication. Many people mistakenly think fresh DIN is needed for new company appointment. That is completely wrong. The same DIN should be used across all directorships throughout lifetime. Link with Section 153 and 154. Section 153 deals with application for DIN, Section 154 deals with allotment of DIN, and Section 155 prohibits duplication after allotment. Together, these sections create identity framework under company law. Link with Section 158. Section 158 requires DIN to be used in every filing. Therefore, Section 155 becomes even more important. Because all filings depend on one consistent director identity. Lead consequence of multiple DINs. Obtaining or possessing multiple DINs becomes violation of law. Penalty provisions under Section 159 may apply. The law treats duplication seriously because it affects governance integrity. Surrender of extra DIN. If a person accidentally obtains multiple DINs, the extra DIN should be surrendered. The original valid DIN continues. The objective is restoration of single unique identity. Fraudulent intent. Sometimes multiple DINs are obtained intentionally to hide involvement in shell companies, conceal disqualifications, or manipulate corporate records. Such conduct may attract serious regulatory scrutiny. Importance for regulators. For ROC and MCA, DIN acts as corporate tracking mechanism. Regulators monitor directorship patterns, defaults, and governance violations through DIN system. Multiple DINs would disrupt entire regulatory framework. Importance for regulators. For ROC and MCA, DIN acts as corporate tracking mechanism. Regulators monitor directorship patterns, defaults, and governance violations through DIN system. Multiple DINs would disrupt entire regulatory framework. Importance for investors. Investors rely on accurate management information before investing. If one director uses different identities, public records become misleading. Section 155 therefore protects investor confidence. Importance for corporate governance. Corporate governance depends on transparency, and transparency depends on unique traceable identity. Section 155 strengthens accountability by preventing duplication. Role of directors. Directors must ensure they use only one DIN. Before applying for DIN, they should verify whether any DIN already exists in their name. Carelessness may create compliance problems. Role of companies. Companies must also verify DIN details carefully before appointment. Compliance officers and professionals should check MCA records properly. This reduces risk of duplicate identities in corporate filings. Practical example 1. Suppose Mr. Prasad Khopkar has one DIN. He uses same DIN across multiple companies. This is proper compliance under Section 155. Practical example 2. Suppose a person forgets existing DIN and applies again. This becomes violation. The person must continue using original DIN only. Practical example 3. Suppose an individual intentionally obtains two DINs to hide involvement in companies facing defaults. This becomes fraudulent and illegal conduct. Practical example 4. Suppose person possesses two DINs simultaneously, even if unused. This still violates Section 155. Extra DIN should be surrendered immediately. Practical example 5. Suppose a director changes address or personal details. Instead of applying for fresh DIN, the person updates existing DIN records. This is correct compliance approach. Why strict prohibition is necessary? Without strict prohibition, one individual could manipulate corporate history easily. Different DINs may create confusion in governance records, and enforcement actions could become ineffective. Therefore, the law adopts zero tolerance approach. Difference between update and new application. Students often confuse updating DIN details with applying for new DIN. Updating means modifying existing records. Fresh application means seeking additional identity. Only updating is legally permitted. Importance of traceability. Traceability means regulators can track entire corporate journey of director through one number. Appointments, resignations, defaults, and disqualifications remain connected. This strengthens regulatory supervision. Governance objective. The ultimate purpose of Section 155 is clean governance system. Corporate transparency collapses when identities become duplicated. One person, one DIN rule therefore protects integrity of company records. Segment 29. Relationship with Section 159. Section 159 imposes penalties for violations relating to DIN provisions. Therefore, breach of Section 155 may attract financial consequences. Students should remember this statutory connection. Exam golden line. Remember the core principle clearly. One person equals one DIN equals lifetime validity. Any duplication becomes illegal under company law. Memory trick. Use this quick revision formula. One identity, one DIN, one lifetime. This captures complete essence of section 155. Exam trap alert. Students often make important mistakes under section 155. First, they think fresh DIN is needed for every company. Wrong, because same DIN continues for lifetime. Second, they think accidental duplication is acceptable. Wrong, because even possession of multiple DINs violates law. Third, they confuse updating details with applying again. Practical example 6. Suppose company secretary notices duplicate DIN during compliance review. The director immediately surrenders extra DIN and regularizes records. This helps restore compliance. Practical example 7. Suppose a person uses different DINs in different ROC filings. This creates serious governance and regulatory concerns. Authorities may investigate intention behind duplication. Practical example 8. Suppose a director changes nationality or address. The correct step is updating DIN database, not seeking fresh DIN allotment. Importance for MCA database. MCA database depends heavily on DIN system. Duplicate identities would create inaccurate public records. Section 155 therefore protects authenticity of MCA data. Corporate fraud prevention. Many shell company frauds involve hidden identities. Section 155 helps prevent such manipulation. Because every director remains linked to one permanent identity. International governance standards. Globally, corporate governance systems focus strongly on unique identification of management personnel. Section 155 reflects international governance principles relating to transparency and accountability. Why students must master Section 155? Section 155 appears simple but carries major practical importance. It connects directly with governance transparency, ROC compliance, and fraud prevention. Students should understand both legal rule and policy objective. Final governance insight. Identity is foundation of corporate governance. If identity becomes duplicated, accountability disappears. That is why Section 155 insists on one unique, permanent, transparent director identity. Section 155 sends one powerful message to every director. Your corporate identity must remain unique, traceable, and transparent throughout your professional journey. Because strong governance begins with authentic identity. That is the true purpose of Section 155 of the Companies Act 2013. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, or any organization or listed company with which the speaker may be associated, shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information (UPSI), confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.